Oyez, oyez, oyez. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Call these the rollaway chairs. Good morning, everyone, and welcome back to day 2 of our October docket here in the East for the Court of Criminal Appeals. We are happy to see everyone. I see some folks that were with us yesterday at LMU, so many thanks again for those who came and participated in that. We had a really good day. So I think we've got 4 cases on the docket this morning. Everybody knows 20 minutes per side, and appellant, let me know if you want to have any rebuttal time. I'll introduce our panel. To my right is Judge Tom Greenholtz from Chattanooga. To my left is Judge Kyle Hickson from here in Knoxville, and I'm Jill Ayers from Clarksville, Montgomery County, Tennessee. So we're happy to be with you all today. Are there any preliminary matters?
No, Your Honor.
All right, if you'll call our first case then, please.
State of Tennessee v. James Elvis Presley.
Good morning.
Good morning.
Your Honor, may I have 3 minutes for rebuttal?
Very good.
Thank you, Your Honor. May it please the court, counsel, my name is Will Lundy, and I represent the state of Tennessee in this appeal. A trial court may grant a defendant a new trial on the basis of newly discovered evidence under Rule 33 if it finds that that newly discovered evidence is likely to change the outcome of the trial. And here, the trial court explicitly refused to find that the new evidence here was likely to change the outcome of the trial. Accordingly, the trial court abused its discretion when it granted the defendant a new trial. Just kind of want to go over some of the facts and procedure here to kind of get into just where we go with this case. The defendant here was convicted of second-degree murder in the beating death of his wife. The defendant was found highly intoxicated in his house where his wife lay dead on the couch surrounded by her own blood. There was blood around the victim's body on the couch. There was blood found underneath the bill of his cap. The defendant alleged that his wife had been drunk and that she punched him in the nose. I think he alleged that she broke his cell phone over his head. He admitted to slapping her 2 or 3 times. He variously claimed that she hit her head on a table and that she must have been out elsewhere in Tellico for the evening, and that someone else must have caused her injuries while she was away. A Dr. William Oliver conducted the victim's autopsy, and he was subpoenaed to testify at trial, but he did not appear. Dr. Darinka Malusnik testified in his stead. The defendant was convicted, and in his motion for a new trial, the defendant argued that a letter from Dr. Oliver to a detective that had not been disclosed to the defense constituted a Brady violation. Dr. Oliver was called to testify at the motion for a new trial, and he testified. The trial court disagreed with the defendant's Brady claim and denied that, but it sua sponte granted the defendant a new trial on the basis of newly discovered evidence in the form of Dr. Oliver's testimony. And again, in doing so, the trial court refused to find that Dr. Oliver's testimony was likely to change the outcome of the trial, which is the standard for granting a defendant a new trial on a motion for a new trial. And accordingly, the trial court abused its discretion, and the state asks this court to reverse the trial court and reinstate the defendant's convictions. On appeal, this court ordered the parties to address 3 issues. First, whether the trial court had the authority to grant a new trial under Rule 33 sua sponte. Second, if so, what the applicable standard is to be employed. And then third, whether the trial court abused its discretion by granting the motion for a new trial. And I want to start by saying that the parties agree significantly in this case. The parties agree that the trial court does have authority under Rule 33 to grant a new trial on its own motion. The parties also agree that under Rule 33, a trial court cannot simply grant a new trial willy-nilly for no reason whatsoever. Instead, a trial court may grant a new trial on its own motion on the basis of a legally recognized ground for granting a defendant a new trial, And when considering whether to do so, the court must apply the same standard that it would otherwise apply if the defendant had raised the issue in the motion for a new trial himself. And again, here we're talking about a motion for a new trial on the basis of newly discovered evidence, and the parties agree that under State v. Nichols, the standard is that the evidence must be likely to change the result of the trial. And again, the trial court said that it could not find that this newly discovered evidence, in this case Dr. Oliver's testimony, as distinguished from Dr. Malusnik's testimony, was likely to change the result of the trial.
So, counsel, we're proceeding only under 33A. We're not proceeding at all under 33D. Is that right?
I believe so, yes.
Is there any discussion of 13th juror?
The trial court did, as 13th juror, the trial court affirmed the convictions, yes. Okay. Yeah. The trial court did apply a standard when it granted the motion for a new trial, but the standard that it applied was the standard that courts apply under the error coram nobis standard, and of course error coram nobis is a creature of statute, and it has a different standard than the standard that's applied under Rule 33. This court has recognized that the Nichols standard appears on its face to be a higher standard than the standard under motion for a new trial, which simply says may have changed the result of the trial. In Vasquez, the Supreme Court at least implicitly agreed with this assessment in State v. Workman, and the Supreme Court has certainly not abrogated or overruled Workman in any sense. The Supreme Court held in Workman that the mere possibility of a different result is not enough to warrant relief under a writ of error coram nobis. And really, when we look at the trial court's order here, where it talks about whether the evidence may have changed the outcome of the trial, what we're talking about is just the mere possibility of a different result. So the question here then, when we're looking at this likely to change the result of the trial, the question is, supposing all the evidence, new and old, to be before another jury, whether that jury ought to return a verdict more favorable to the defendant than the one returned on the original trial. And because we have to look at both the old evidence and the new evidence as though it was both presented to the jury, what's relevant here are simply the distinctions between Dr. Oliver's testimony and Dr. Malusnik's testimony. There are three differences. First, Dr. Malusnik concluded that Mrs. Presley had been beaten with an object, whereas Dr. Oliver concluded that she had not been beaten with an object. Second, while Dr. Malusnik concluded that many of Mrs. Presley's injuries were inconsistent with a fall, and in fact Dr. Oliver said that many of her injuries were strongly inconsistent with a fall, he did conclude that this sort of counter-coup injury that she sustained to her brain may have been caused by a blow or a fall. And then the third distinction is that while Dr. Malusnik concluded that Mrs. Presley's injuries would have immediately incapacitated her, Dr. Oliver testified that he couldn't say whether Mrs. Presley's injuries would have incapacitated her immediately. He had no idea whether she might have been ambulatory in the hours leading up to her death.
So your friend on the other side suggests that this is not merely an impeachment case. That if it were an impeachment case, maybe we'd be under one standard. But as I understand the argument, it's not only is Dr. Oliver's testimony impeaching perhaps the medical examiner's testimony, but it also is supporting the defense case. Maybe even with Dr. Whitaker, reinforcing Dr. Whitaker perhaps. And so this isn't really just a case where we have the state's medical examiner being impeached. We have a witness coming in who is impeaching the state's expert and providing support for the defense theory. What's the state's response?
Your Honor, I don't think that Dr. Oliver's testimony, at least it doesn't directly support the defendant's theory of the case or directly contradict the state's theory of the case.
When Dr. Oliver, though, says, I look at the medical proof and I can't reach the conclusions that the medical examiner is reaching, I can't get there. That seems to be support on causation as well as perhaps some other things as well. So.
It would be tangentially related to causation, but even if, well, first of all, I do want to point out, as you said, it may support Dr. Whitaker's testimony. Dr. Whitaker was an emergency room doctor and an internal medicine doctor, So, and she testified, based on the evidence in this case, that that Mrs. Presley probably would have been able to walk around and be ambulatory. So Dr. Oliver's testimony on that point is really just cumulative to what Dr. Whitaker said.
But Dr. Oliver examined the body.
Right, Dr. Oliver did examine the body.
So Dr. Oliver is the one who performed the autopsy, and so I would think that opinion is something more than just being merely cumulative.
I don't think it is, at least on that point, because Dr. Oliver's testimony about whether she would or would not have been ambulatory is speculative. And, I mean, it's just based on his understanding of the injuries and how those injuries may or may not have occurred and the severity of those injuries. And I want to point out, Dr.
Is it speculative, or is it speculative, or is the testimony really, when I look at the medical evidence, I'm unable to conclude that she wasn't ambulatory? Which means that she might have been, but the medical evidence doesn't reach the conclusion that the medical examiner reached in the case. Subsequent medical examiner.
Dr. Whitaker said the same thing. And I would say Dr. Whitaker's testimony would be actually more powerful than Dr. Oliver's testimony, simply because Dr. Whitaker talked about how she had seen people with these kinds of injuries up and walking around. Dr. Oliver, on the other hand, he's dealing with corpses. He's not seeing people up walking around with these kinds of injuries.
But he's also dealing with the autopsy. And I guess that's where maybe I'm pushing back just gently a little bit on this. It seems like the medical examiner who's performing the autopsy, who sees the body, is in a much different position to be able to render an opinion either on causation or other issues than maybe other witnesses. And we're saying here that the medical examiner's testimony, the person who saw and examined the body, that testimony is merely cumulative to someone else who did not?
I mean, as far as whether or not the victim was able to be up and walking around, yes. We simply have two experts. I mean, both of whom. I mean, Dr. Whitaker was shown the evidence that of the injuries, and she was able, in her professional opinion, to render an opinion which was the same as Dr. Oliver's, and the jury simply rejected it. Or actually, and let me backtrack. I don't want to say that the jury rejected it. Okay. The jury could have rejected it. That's certainly a possibility, but the jury might have accepted that testimony as well. And even if it did accept that testimony, there's no reason for the jury to have concluded that Mrs. Presley was anywhere except in the house at the time of the murder.
But
so even if you accept...
Doesn't it support the defendant's own statement that she sustained these injuries in Tellico? And for the jury to hear that from the state's medical examiner, wouldn't that carry much different weight, potentially?
I guess I don't see how it would carry any different weight than Dr. Whitaker's testimony. Again, and that's primarily because Dr. Whitaker, as an ER doctor, has seen people with these kinds of injuries up and walking around. And again, even if it provides some degree of plausibility for the idea that the victim here may have been able to walk around, the jury could have easily concluded that, yeah, she was able to be up and walking around in the hours before her death, but she didn't leave home, and that doesn't answer the question of whether the defendant caused these injuries in the first place.
What would happen here maybe in a hypothetical situation where you have Dr. Oliver testifying as the state's medical expert, Dr. Malusnik is not testifying? The state doesn't meet its burden of proof, does it?
Yes, I think the state still does meet its burden of proof.
How so?
Well, as I've said, given Dr. Oliver's testimony, first of all, we have,
I thought you said, and I didn't mean to interrupt, but I thought you said that Dr. Oliver's testimony was speculative. So if Dr. Oliver is testifying, the state doesn't meet its burden of proof, does it?
No, and I mean, the Dr. Oliver's testimony was speculative insofar as he's saying, she may or may not have been able to walk around. In fact, he literally admitted that he had no idea whether she was going to be able to walk around. And so, I mean, I understand your hypothetical, but of course the standard, that we have to apply here is assuming that both experts testify. And Dr. Malusnik's testimony is far more, I guess, black and white, if you will, than Dr. Oliver's.
I know we're fighting the hypothetical, but just with the hypothetical,
sure.
If Dr. Oliver was the state's medical proof, does the state meet its burden of proof?
Yes, I believe it does absolutely meet its burden of proof. So, Dr. Oliver testifies, first of all, that Mrs. Presley was pummeled to death. Dr. Oliver testified that she was pummeled to death. He put that in his, in his report. He concluded that she didn't die by some sort of an accident. This was a homicide, and that she was beaten to death. He also said that many of her injuries are not consistent with a fall. Again, all the injuries around her face and her eyes and her ears, inconsistent with a fall. Even if, and again, if he had perhaps said that Mrs. Oliver fell and that her death was an accident rather than a homicide, we probably do have a different case, but he didn't say that. He said that she was pummeled to death, and that, and so that she was, and so this was a homicide case. So, and again, back to the differences, Dr. Oliver said that he thought that the Mrs. Presley was beaten to death with someone's bare hands rather than an object. And given the extent of her injuries, I don't think there's any reason to believe that the jury would have acquitted on second-degree murder simply because he beat her to death with his bare hands rather than with some kind of an object. When we look at this fall that she may or may not have had, again, there's no reason for us to conclude, no reason for the jury to conclude that she didn't fall as a result of the defendant punching her in the face or beating her up or whatever, and so that he's responsible for that injury, even if it was ultimately a fall, hits the ground coup, counter coup with the brain.
But your friend on the other side, maybe even agreeing with that point in part, suggests that there could be a different mens rea, and so that the knowing mens rea may not apply if you take Dr. Oliver's testimony, and that it's more likely a reckless homicide. What's your response to that?
I just don't think that's the case. I don't think that's true.
Why?
Again, mostly because of the extent of the victim's injuries. The victim, we look at her injuries, and she was bruised about the head, and there was only, I believe, one area next to one of her nostrils that wasn't bruised and bloodied. The jury was able to look at, they looked at the body, they looked at the crime scene. There was blood spatter underneath the bill of the defendant's hat. I don't think looking at the severity of her injuries that we get reckless or negligent homicide here. I think the jury is right to find knowing homicide, and that's true whether the defendant used a weapon or not. And I know that the use of a weapon is something that this court looks to when we talk about the sufficiency of the evidence for for a second-degree murder, for a knowing killing. But again, I don't think it matters here, given the extent of the victim's injuries, whether the defendant beat her to death with with his bare hands or with some sort of a weapon. Again, I want to go back to the fact that the trial court here concluded, it refused to conclude that Dr. Oliver's testimony was likely to result in to produce a different result in a new trial. The standard is that the trial court had to find that this evidence was likely to produce that result. The trial court refused to find that the evidence was likely to produce a different result.
Is that because the trial court applied the quorum nobis standard?
What's that?
Is that because the trial court applied the quorum nobis standard?
Explicitly in its order, the trial court said that he couldn't find that the evidence was likely to result in a new trial, and so it wrongly applied. Insofar as it applied the correct standard, it applied it wrongly because it didn't make the findings it was obligated to make. But insofar as the court applied the error quorum nobis standard, that's the wrong standard, and under an abuse of discretion standard, when a trial court applies the wrong legal standard, that's an abuse of discretion. Accordingly, the state asks this court to reverse the trial court and reinstate the defendant's convictions. Thank you.
Thank you. Mr. Gill.
Good morning, Your Honors, and may it please the court. William Gill, here this morning on behalf of the appellee, Mr. Elvis Presley. I will start out by pointing out that there are a couple of points of agreement as to the issues that this court asked us to address in this case. So number one, we agree that the trial court is authorized to grant a new trial on a legal theory or a basis that is a little bit different than what was set forth in the written motion for a new trial. And it's very understandable how that came about in this case, because the newly discovered evidence did not exist at the time the written motion for a new trial was submitted. So it was submitted as a Brady claim, and then Dr. Oliver testified at the hearing on the motion for a new trial. As soon as his testimony was on the record, I will note that trial counsel did argue that his testimony, as well as the letter justified granting a new trial in this case. The second thing we agree on is that the trial court should have some legal basis for granting a new trial. I don't think that's a radical proposition, that the trial court does need a legal basis. Where we disagree is that we believe that the record shows rather emphatically that there is a legal basis for granting a new trial in this case based upon the post-trial testimony of Dr. Oliver, who was, of course, as the panel noted, the forensic pathologist who performed the autopsy in this case.
So what is the standard? So the state's brief suggests, I think, without actually saying it, that really what the defendant is arguing something under the federal standard, under 33A, such that the trial court, the district court,
Should be other way.
we're having issues with the microphones. I don't know if we can fix this, but thank you. Such that the defendant may receive a new trial if it's in the interest of justice, whereas under our rule, you can receive a new trial if it's required by law. So is the defendant here proceeding under the required by law such that we have to import, for example, the Nichols standards for discovery of new evidence or the quorum nobis standards or something like that?
We agree that the usual standard for newly discovered evidence applies, which is consistent with the Nichols standard in other cases. As you noted, the interest of justice language does not appear in Tennessee's rule. I think it's a rather good idea to rule in the interest of justice. That's certainly better than the interest of injustice. And so while
but we're governed by legal standards, though, right?
I can see that. Yes, Your Honor.
That's fine. Okay.
But there is, again, a basis for in this case. And I will notice that what my friend takes issue with primarily is that the trial court mentioned both standards in its order. This was a rather long order on the motion for a new trial. And the trial court mentioned the quorum nobis standard, which is whether the evidence may have altered the outcome of the new trial. The trial court also mentioned the typical standard that applies at a motion for a new trial stage, which is whether the evidence is likely to produce a different outcome. I will note that in the Tennessee Supreme Court's most recent case on this issue, State versus Hall from 2015, the Tennessee Supreme Court also cited both of those standards in its analysis and did not distinguish between the two standards. That's a case that is more recent than any of the cases on that issue that my friend has cited. And so I think what that suggests is that there is just not as big of a difference between these standards as the state would suggest, or even as the trial court maybe thought there was. And the evidence here is sufficient to meet either standard. Looking at the evidence and the trial court's specific findings, not just its conclusion, but looking at the trial court's specific findings, it's apparent that this standard is satisfied. And there's an aspect of this standard that respectfully I think the state has sort of hidden from, not acknowledged in its brief, not acknowledged in its argument. And that is that when we're looking at newly discovered evidence, the court must presume that the newly discovered evidence would be produced and accepted by the jury at the new trial. So let's think about what that means. That means the court must presume that the jury would adopt Dr. Oliver's opinion, expert opinion, that no object was used to strike Ms. Presley. The court would have to presume that the jury would adopt Dr. Oliver's finding that the injuries, that the most serious injuries, the ones that caused the subdural hemorrhaging, exhibited a classic pattern for a fall and were strongly suggestive of a fall. The court would have to follow Dr. Oliver's finding that in his expert experience, that people who are highly intoxicated, like Ms. Presley was at the time of her death, are notorious for falling down and getting brain bleeds. The court would also have to follow Dr. Oliver's opinion that there is no way that any forensic pathologist or anyone else could look at this autopsy and determine that Ms. Presley immediately lost consciousness upon receiving the blows that caused her brain bleed. And so if the court...
I thought maybe I was under a different impression about maybe what the testimony was. So will you help me, please? I thought, as your friend on the other side suggested, that Dr. Oliver also said that the victim was pummeled, that was strongly inconsistent with a fall, that there really wasn't and that was, you had injuries to the ears, to the eyes, other places that would be inconsistent with the fall. I mean, wasn't that also Dr. Oliver's testimony?
In a sense, but I think it's a little bit different than that,
Okay, yeah,
respectfully.
please help.
So Dr. Oliver testified certainly that there were blows to the victim's face that were consistent with being beaten or being pummeled. Indeed, that is consistent with Mr. Presley's statement to the police. He acknowledged that he was in an altercation with his wife that day. And so I think it is undisputed that there were some blows delivered by the hands of Mr. Presley. However, we go in a very different direction when Dr. Oliver starts talking about the more serious injuries, the ones that caused the subdural hemorrhaging. And so the cause of death here was multiple blunt force trauma, suggesting that it was, not any one blow, but there were blows that were more serious and blows that were less serious. And it was when Dr. Oliver was talking about the blows that were more serious that he indicated that those blows exhibited a classic pattern for a fall. That's a direct quote from the record. Strongly suggestive of a fall, consistent with her being highly intoxicated and falling. And of course, we have this scenario where my friend even acknowledges it's possible under Dr. Oliver's version of the testimony that some blows were received during the altercation, but the other more serious blows resulted from a fall that could have taken place in their residence during the altercation or after it, outside of the residence as she was gone for 2 hours in the dark, walking around. And that fact pattern is way more consistent with a reckless homicide. I think the Tennessee Supreme Court's decision in State versus Parker is highly instructive on that point. In that case, you had a situation where the defendant attacked the victim, an elderly victim, choked the victim, pushed her or threw her to the ground, and when the victim was thrown to the ground, she hit her head and experienced subdural hemorrhaging. The court held that the evidence in that case was insufficient to establish a knowing killing as is required for second-degree murder. Instead, the court reduced it to reckless homicide. So once again, if the jury had that view of the evidence, they would be far more likely to come back with a conviction on the lesser included of reckless homicide. And I think going back to that aspect of the standard of review, that the court must accept the newly discovered evidence. We must presume that the jury would accept the newly discovered evidence. That means they would reject all of the contrary evidence of Dr. Malusnik. For example, the jury would have to reject Dr. Malusnik's testimony that Ms. Presley was beaten to death with a heavy frying pan or a similar blunt object. The jury would have to reject Dr. Malusnik's conclusion that the beating necessarily occurred, that she was beaten to death with a heavy object on the couch where her body was found. That was the only conclusion that Dr. Malusnik said was permissible from the medical evidence. The jury would have to reject Dr. Malusnik's testimony that not a single one of the injuries was consistent with a fall. And so essentially at trial, you had Dr. Malusnik's testimony. She was the only forensic pathologist who testified. Dr. Whitaker acknowledged that her expertise was inferior when it came to any of the medical findings in this case because they were based on autopsy materials. So we had the opinion of one forensic pathologist, and Dr. Malusnik's view only allowed for one conclusion, which was that Mr. Presley beat Ms. Presley to death with a frying pan or a heavy object on the couch where her body was discovered. That is highly suggestive of second-degree murder. This court has cases going back many years. We see the State versus Madden case where someone was beaten to death while they were on the ground, unconscious or not moving, second-degree murder. We see the Madden case where the defendant beat the victim to death with a piece of lumber, second-degree murder. Conversely, when we have a situation where the less serious blows did not cause the subdural hemorrhaging, and the more serious blows were quite likely produced by a fall, the evidence is more consistent with reckless homicide. I'll just briefly address some of the state's arguments which again, we would contend do not justify disturbing the grant of a new trial in this case.
Mr. Gill, in going back to the standard, maybe that the reviewing court must believe that the jury would have accepted the evidence. What is the authority for that? Is that Goswick?
Yes, sir. That's State versus Goswick.
I mean, reading Goswick, most of the time I'm seeing in Goswick where the court is hedging it, saying that it would be likely to change the result if produced and accepted by the jury. And once again, at 359, likely to change the result if produced and accepted by the jury. I don't see where Goswick itself is holding that the reviewing court must find that the jury would have accepted it.
I believe in the standard of review language, and this is cited in our brief, it says that the court must presume that the jury would, that the evidence would be produced and that the jury would accept it. And then when the court, if I'm not mistaken from my recollection of that case, the parts you're reading from.
It's okay. I don't see anywhere where it's talking about a presumption.
I'll pull it up in my brief.
That's okay.
Okay.
Goswick is the authority.
Goswick is the authority, and my understanding is that when the court got to the application, the court was using the word "if" conditionally as a means of sort of expressing that by saying, so if this evidence were produced and accepted, it would lead to a different result, and as a result, the court in Goswick did say that a new trial was necessary.
Okay, fair enough.
I wanted to address a couple of things that came up during the state's argument. First, we definitely dispute the notion that Dr. Oliver's testimony was limited to impeachment value. Dr. Oliver's testimony clearly supported it had independent significance in that it supported the defendant's case. Mr. Presley, this is from the trial court's more specific findings. The trial court found that Dr. Oliver's expert testimony would provide Mr. Presley with the means to credibly argue to a jury that tangible evidence exists in this case to support his theory and to question whether reasonable doubt exists that he is guilty of second-degree murder. And so I think the trial court's specific finding on that point is entitled to deference and is accurate, that Dr. Oliver's testimony supported the notion that contrary to Dr. Malusnik's testimony, Ms. Presley was not beaten to death where she lay, that instead there may have been an altercation, and that in addition to that altercation, there was likely a fall or multiple falls that produced the most serious injuries, leading to her death. The trial court also found that there were significant factual differences on matters in germane dispute between Dr. Oliver and Dr. Malusnik, and I think that suggests that certainly Dr. Oliver's testimony would contradict Dr. Malusnik's, would potentially supplant her opinion since he would be the forensic pathologist who conducted the autopsy. Moreover, I will note that the trial court found that Dr. Oliver was highly credible and of equal expertise to Dr. Malusnik when it came to the field of forensic pathology. We would also dispute that Dr. Oliver's testimony was cumulative to that of Dr. Karen Whitaker. Dr. Karen Whitaker was the ER physician who was on call that night. She never saw Ms. Presley's body. Her only real role in this case was to perform the ministerial function of signing off on Ms. Presley's dead body being transferred from the ambulance or the emergency room to the medical examiner's office.
Was she a forensic pathologist?
No, Your Honor.
In fact,
She was tenured, I believe, as an expert. She was an emergency physician. I believe she was tenured as an expert in, as an emergency physician or in internal medicine, perhaps. She quickly, and I respectfully disagree with the characterization that she testified that Ms. Presley was ambulatory or that was possible. She testified generically that a person who has a brain bleed or subdural hemorrhaging can sometimes be able to get up and walk around. Her only exposure to the medical evidence in this case was when she was shown by the prosecutor the autopsy report that Dr. Oliver had produced. As soon as she was shown that, she was quick to say that autopsy materials are outside her field of expertise. As an emergency physician, she is accustomed to making these determinations based upon CAT scans, things that you would do to someone who is still alive in an emergency room. not autopsy procedures. And so her testimony was extremely qualified in that way. And as soon as she was shown that, she tentatively said that she supposed it was possible that someone in that condition could have been ambulatory, but she hedged significantly, whereas Dr. Oliver was unequivocal. He said there is no way that any forensic pathologist could look at the medical evidence here and determine that the person lost consciousness immediately, which is, of course, exactly what Dr. Malusnik had purported to conclude in her testimony. Moreover, Dr. Oliver testified to many things that were not even covered in Dr. Whitaker's testimony, nor could they have been. That includes the use of an object. Dr. Whitaker did not say anything about that, nor did Dr. Whitaker opine as to whether any of the injuries were consistent with a fall. And because she had not seen the body, she really had no basis for delivering any opinion like that. In summary, the newly discovered evidence in this case warrants a new trial because it is likely that a jury accepting Dr. Oliver's testimony would reach a different outcome, such as a conviction on the lesser included offense of reckless homicide. As a result, this court should remand the case so that it can proceed to a new trial. If there are no further questions, thank you, Your Honors.
Thank you. General Lundy?
Thank you, Your Honor. Excuse me. I do want to go back to the fact that my friend and I agree that the proper standard.
Can you just back off that mic a little bit? They're really hot today.
Yeah, it is a little
Kind of
hot.
reverberating
I'll
in
try
here.
and stand. Is this better?
Well, maybe just a little
I don't know
closer.
where to stand.
Perfect.
All right, thank you. I apologize. I just want to just touch base again. The trial court, in order to grant a new trial, a trial court has to find that the evidence, this newly discovered evidence, is likely to result, in a different result at trial. And the trial court here explicitly said that it couldn't find that this evidence was likely to produce a different result at trial. Your Honor, that's an abuse of discretion. It's a misapplication of the standard. And although I've already addressed a lot of this in my original argument, but even if we accept the defendant's argument that the jury must be presumed to accept what Dr. Oliver's testimony in this case, which I don't concede, and on the grounds that Judge Greenholz has elucidated for us. But even if we assume that, as I've argued before, even if the jury is still absolutely entitled to conclude that the defendant beat his wife to death. Under Dr. Oliver's testimony, he simply beat her to death with his bare hands, and all of those horrific injuries that she suffered, he caused her with his bare hands rather than some kind of an object. All the blood, all the bruising, all the contusions, all of the mess, all of the injuries caused by his bare hands. And I would argue that the jury would find that the defendant was guilty of second-degree murder rather than some lesser-included offense. Secondly, again, there's no. Let me back up. I do want to point out that Dr. Oliver did not testify that this was an accident. He did not conclude that this was an accident. So again, if we're looking at whether or not the victim fell in this case, the conclusion would be that the defendant caused her to fall as he was beating her to death. There's no sense in which Dr. Oliver testified or opined in any way that this was some kind of an accident. He opined that this was a homicide and that this woman was pummeled to death. Not that she accidentally fell and bonked her head, but that she was pummeled to death. And so even if we accept Dr. Oliver's testimony, the state's position is that the evidence here is inadequate to justify granting a new trial because it's not likely that a jury would return a different verdict. With that, my time is up. I would simply ask this court to reverse the trial court and reinstate the defendant's convictions. Thank you.
Thank you. All right, thank you both for your really good briefs and arguments here today. Interesting case that we will consider. And if you'll call the next case, please.